This open meeting portion of the Conflict of Interest Board meeting for today is being conducted pursuant to the Public Officers Law. We will have before us for consideration three proposed rules of the board. They deal with open meetings, rules 401, 02, and 03. They deal with annual disclosure, I'm sorry. Investment in securities, a proposal on board rule 1-04, and gifts, which 1-01, I, J, K, L, and M. So why don't we begin, of course, with the annual disclosure proposal. This has been before the board. It has gone before the public in an open in a public hearing. It is now before us for final action. I don't know if Julia, you want to say more on this, or any member of the board has additional comments or questions on this, but if not, it would seem to be ready for adoption as a final rule and publication in the city record. So are there further comments, or Julia, do you want to add anything more to what we've said on this rule in the past?
No, nothing further to add.
Okay. So are there any objections to voting to proceed and publish this as a final rule of the board? All in favor?
All in favor.
Okay, no objections. Let's move on to the next rule. This is now before the board for discussion and deals with investments in publicly traded securities, and is part of our efforts to consolidate rules pursuant to the direction of the City Council to look at and examine previous opinions of the board and consolidate them in rules. So maybe Chris, to begin, maybe you want to just take us through what the proposal is?
Yes, I'm happy to.
Okay.
Yes, so the board is seeing these proposed amendments to Board Rule Section 104 for the first time. The existing rule defines, for purposes of Chapter 68, a publicly traded stock. That is paragraph A in the proposal, and that's unchanged with one grammatical fix. The proposed amendments would add 3 paragraphs regarding mutual funds, individual retirement accounts, and the ownership of bonds. So paragraph B deals with mutual funds and defines a mutual fund within the definition of ownership interest contained in Charter Section 2601(16). Investments in investments held in individual retirement accounts appear in paragraph C, and then investments in public debt obligations appear in paragraph D.
Okay. I guess that tells us what's in the rules. Do we want to talk about what is in each of these proposals, or how do we want to proceed? Any members of the board have questions or comments, preliminary questions and comments, because I assume we will continue to discuss this. I mean, I've got a few questions. I guess others do. I don't know. Do we want to discuss at this point particular provisions of this, or having it? Do we want to give it further consideration and discuss at a future meeting, and perhaps submitting some of our questions to council if we have legal questions? I don't know how we wish to proceed with this.
I think as many questions as we can pose during this open meeting process, that's what would be ideal.
Okay, I've got, so does anyone have questions or comments that they want to begin begin with on these proposed rules?
Maybe if we go, if there are any general questions first, and then we can go paragraph by paragraph, that might, so that we can discuss one topic at a time. That might be what I suggest.
Jeff, or start us off with the question that
Well,
you have.
I'll start off and maybe with particular section and
Okay.
the section on mutual funds and sectoral funds. That is something new. That is
Yes.
that it does not exist in our current rules. It does not exist. I don't think we've dealt with that in our advisory opinions. So that is a new proposal. So my first question would be, why are we proposing that at this point? I understand there's some language in federal provisions that make a distinction. I don't know necessarily that this is applicable to what we do here, or how exactly it would apply, because mutual funds, presumably over which the employee has no control, that is, are invested by advisors and others, and not the employee, are not ownership interests. So this would, as I read it, if there is a sectoral mutual fund, that could become an ownership interest. And the question is, what sector applied to what city position? And second, how does one deal with that? Is the sectoral mutual fund, if you've got a $50,000 or more investment in a mutual fund as a whole, is that considered to be an interest? Or is it in a particular security or within that fund? I'm just a bit confused as to and what sector would apply to what position. And maybe in the federal government, if, for example, you're heavily invested in a fund that invests in communications securities, and you're being appointed to the FCC, or you have a fund dealing with arms or arms, munitions, or airplane stocks, and you're being appointed Secretary of Defense, there may be an issue there. But I'm not exactly sure how this applies to the city, and how one would compute what is the holding that is of concern. So I'd like to hear some discussion of that, but also, why is it that at this point this has not been an issue? And given that our mandate here is to consolidate what we've done before, why are we introducing that here? So that on that, and just related to on the holdings of IRAs, for example, the law is pretty clear now that it's IRAs where the employee has no control. If in fact there is a particular stock within an IRA, I don't have an investment like that, but if you could put a particular security into your IRA, and that of course has some relationship to business dealings with the city, I think that's already prohibited by Chapter 68. So I'm not sure why we are proposing these changes. And then finally, to go on the stock investment, on the bond investments by people substantially involved. I guess that has been our rule, right? That is a codification of what we've already said. So that, put that aside. So I'm just I have questions about both the reason and the mechanics of the other two provisions. Appreciate more discussion or consideration going forward. Yeah.
So Jeff, let me try to sort of answer the big picture question of the why do this, and the one part of the answer is when you were talking about this is an attempt to try to figure out what is a kind of investment where owning that investment is not something that's going to be a way that a public servant can privately benefit themselves through the decision making they're engaging in as a public servant. And the advantage of a diversified mutual fund is that it's such a broad and diverse investment that it's essentially an investment in the economy generally, and not something where actions that you're taking as a public servant are going to affect your private investments in a way where you're going to benefit personally. The narrower the scope of the investment, the greater the risk that that's going to be the case. And we are proposing to follow the federal government's concept about this by saying that sector funds are not diversified mutual funds for the purposes of the city's ownership interest definition, which only means that if a fund has a stated policy of investing in a particular sector, that we think it's no longer diversified enough to say that it's just the economy generally. And all it means then is you have to actually look at what's you have to look inside of it. You don't just get to put it in there and not worry about it. You have to actually look at what's inside the investment. And so that's the concept of it. Most public servants who are investing in sector funds are not going to be investing enough money in a sector fund to ever hit any of the financial thresholds in the conflicts of interest law for it to prohibit them from taking action. This is mostly going to be something where somebody is a rather wealthy public servant and has chosen to invest their money in a fairly targeted fashion. So this is not going to be impactful for run-of-the-mill folks. It's just going to be a handful of very wealthy people who are likely to be impacted by this. And I think the reason to do it is not only to sort of prevent these conflicts, but also to provide some clarity about what a mutual fund is for Chapter 68 purposes. I think people have relied on it being a fairly broad definition, and so it's not necessarily the case that anyone would feel that they need to come to us to get an explanation of whether it includes sector funds, because it's so vaguely defined and really undefined in the charter.
I mean, just to build on that slightly, a mutual fund is entirely exempted from the definition of ownership interest. Mutual funds, public servants are not obligated to open the hood and look inside. They're not obligated to come to us. A sector fund, because it's targeted, has sort of a much higher risk of coming across a public servant's actual city duty. So, for example, there are real estate investment trusts that are publicly listed on the stock exchange, and it's not beyond the realm of possibility that a public servant's obligations as part of their city duties might impact the investments of that real estate investment trust. Or the city is a major player in the development of energy resources. We're a buyer of energy, and the city is involved in discussions with suppliers of energy about how that energy is produced and how the city can get it. So a public servant who has a targeted investment in energy resources could conceivably be bumping up against that interest in their city job. From the way I'm discussing it, it's sort of obvious that we're talking about a relatively small group of people for whom this is going to be a problem. But the problem is that the existing definitions for these sort of investment vehicles it's a little bit outdated. And we need to sort of tool up the definitions in response to the sorts of investments that people have.
Could I follow on that? And this, I think, is what Jeff was asking in the first place, from what you say, Chad, and what Ethan says too. I gather that when you're talking about the amounts involved and hitting those thresholds, it's only going to be a small number of people. It seems to me that you're answering Jeff's question that the $50,000 or the $10,000 amounts, whatever we're talking about, but let's just talk about 50 because we're talking about ownership interest, only apply to the effective ownership share of the individual holdings within the fund, and not a $50,000 investment in a sector fund, because not a lot, but a lot more people than a few of the, we'll call them the Richie Riches, could afford $50,000 perhaps in a sector fund. But I guess you're answering Jeff's question. Am I right that you have to look at the 50 only as your effective ownership share in the components, right?
Yes, that's exactly right, Wayne. Do
you even, as a matter of just, I don't happen to have that kind of money in a sector fund, but do you even know what the effective, you got $300,000, let's pick a number, $500,000 in an energy sector fund. Do you know how much of that is effectively in Con Ed, for example?
There's a report, and that's all disclosed.
It's knowable to the public servant who might be impacted by that. It's something that's both knowable, and it's not information that's particularly difficult to get for somebody who has, for the rare public servant who has enough money in a sector fund that they might be affected by this type of thing.
Okay.
Right. So my major question was whether we're dealing with the fund itself, $50,000 or $50,000 in a particular holding within that. And I think we've answered that question. So I think that helps me with this substantially. So are there other questions on this particular portion of the rule? Okay, again, on the IRAs, again, you would look to see whether there's a particular stock within it, or if one is in a position to, I guess an ownership interest includes firms held where the investment is not firms held in an individual. I'm a little.
Yes.
Yeah. Why don't we go through that?
Yes, I'm happy to walk you through that. Walk everyone through that. Basically, what this paragraph is saying is that for an individual retirement account, a Roth IRA, a simplified employee pension IRA, and a Keogh plan, that's simply an account. These are types of accounts that different investments are go into those accounts. And so we just look at those individual investments to say, in my IRA, I own $50,000 in X stock, and that $50,000 in X stock will be the ownership interest that's relevant for Chapter 68. The fact of the account, you have to look into the account where these types of accounts are accounts where public servants are choosing the investments that go into it. So we're saying you don't get a free pass simply because these are accounts that have to be deferred to your retirement in order to withdraw. That the ownership of individual stocks within these accounts will trigger the $50,000 ownership interest requirement. If they are mutual funds, diversified mutual funds that would be excluded from the definition of ownership interest, those remain excluded whether they're held in any type of brokerage account or an IRA.
Right. So in fact, if you know there is an investment of $50,000 or more within an IRA, it is not excluded as an ownership interest simply because it is deferred in an IRA. So
that's exactly right.
What the charter says, but I see no objection to saying that. Getting back to the previous discussion, let's look at the language itself, if you could, and let's be sure that what it's actually saying is that we're talking about the individual investment, not that it talks about investment in companies, funds, or trusts that have a stated policy. It would be investments in companies within a fund that has a stated policy. If we could maybe massage that language a bit to make it clear.
Yeah, you're talking about for the mutual funds. So because mutual fund is a term that excludes something from the definition of ownership interest, this is just defining the scope of that exclusion. So already in the definition of ownership interest in Chapter 68, it says that mutual funds out of the control of the public servant are excluded. This is just explaining what a mutual fund is for purposes of that exclusion, and so and it's limiting that exclusion to just those mutual funds that do not have a stated policy of concentrating their investments. So that would exclude sector funds, for example. But this doesn't. If you want to understand what what the prohibition is, you'd still have to look at the charter to understand why this definition matters.
Ethan, in the IRA provision, we're explicitly saying you look at the companies held within the thing, and I think Jeff's question is why here under mutual funds there isn't something that says if it's a sector fund, you then look at the holdings within your sector fund. Jeff, have I got that right? I think
Right. If you look at the individual,
it's a parallelism between the mutual fund and the investment.
Got it. Yeah, no, thanks. That helps. So yeah, so we can add a sentence or phrase in there, somewhat like what we've got in the IRA section to try to capture that parallel. Gotcha. Okay, I understand. I'm sorry, I was misunderstanding that question. Yeah, it makes sense.
Yeah, we're happy to take a stab at that and try in bringing it back to the board next month.
All right. Are there more questions or any other questions or comments on this before moving on to the next proposal?
I have a question about whether we talked to financial accountants or we have some knowledge of the broad range of options that we have before we go forward. So I wanted to know if you talked to any, or the budget, or who do we talk to about this?
Right. I mean, we have, some familiarity with dealing with these things just from having dealt with them for a while and obviously through the annual disclosure process, but we haven't reached out to anyone to talk about this yet. We certainly can if you feel like that would be a good idea, and, probably and we can think about who those people are. There might be people actually at the comptroller's office who would know a few things that would be helpful for us about this. And also our colleagues in the federal government who have a lot more experience with these different kinds of investments than we do at the Office of Government Ethics. So happy to do either or both of those things.
That's a great suggestion.
Yeah, I think talking to both, if possible, would be really useful.
Happy to do it.
Okay, so then we move on to gifts, and maybe Chad, you could take us through what it is in general being proposed, and then we could talk about it more particularly.
Sure. So proposed board rules I, J, K, L, and M are sort of the last few cars of the train of the gifts rule. And proposed board rules I, J, and K would be codifications of existing sort of standards or concepts that the board has articulated in some of its advisory opinions. And then proposed board rules L would be a tune-up of the existing steps that public servants must take when they receive an otherwise impermissible gift. And then M is a reorganization of existing provisions in existing I, J, and K so that they're just in one place, and it's a bit of a cleanup there. So would you want maybe for me to introduce each in turn, and then we could discuss?
Yeah, why don't we introduce each one, and then let's see if anyone has comments on each one. Maybe
Sure.
a way of dealing with this.
So proposed board rule I is a codifying sort of a 4-part test for public servants to use when a city agency is accepting gifts of tickets of free attendance for use by its employees, and the stated purpose of that being to boost morale. So if, for example, we were in a world where we had mass sporting events, this would permit the Department of Education to accept a gift of Yankees tickets to be distributed to teachers and paraprofessionals for the purposes of boosting agency morale.
But it would be, but again, looking at the other, there's several, there's several subdivisions here, right?
Yeah. The requirements for the gift are that the public servants are not supervisory or managerial, that the gift is unsolicited, that the Department of Education is approached by the Yankees with these tickets, that the method for selecting attendees is approved by the agency head in writing, and that the public servants who are attending the event are not involved in any consideration of pending particular matters or other types of events by the giver. And the goal of this is to sort of make sure that it is sort of insulated from any possible conflicts of interest, that the public servants who are attending aren't being picked for purposes of favoritism or to curry favor by the giver. It's a proposed rule that sort of has in mind the teacher, the paraprofessional, the child protective worker, the person who cleans the parks in mind. It would prohibit, for example, a developer giving a gift to a city agency with sort of the intention of targeting the people who might be considering an application by that developer.
Now, prohibiting the participation of supervisory or managerial personnel, I mean, that's a very broad category. I mean, there are many managers, city managers, who really perform relatively low-level functions. And then when you get into supervisors, as we know from our work, I mean, that there are supervisors on many different levels. And I wonder if maybe high-ranking supervisors, or there may be some way of limiting that, because there are people supervise other people. There are managers in an M1 situation, for example, that maybe it's too broad.
I think that's right, Jeff. I think supervisor here might be misleading because it has this sort of separate, almost technical meaning within the law that we administer of basically anyone who can affect anybody else. So I would definitely propose to remove supervisor. Would the attending public servants are not managers? Would that sort of address the concern, or would you want?
No, there are, you know, maybe Anthony has some knowledge on this, but there are low-level people who are in the managerial pay plan in the city, who are managers, who really do not have a large scope of authority. In fact, who may be employees who can use who can use support.
Boost. Who could use? I don't think that's definitely not wrong, Jeff. But the point of sort of this plan is that this is something for which people do not have to speak to us. That the restriction is written in a way that these are gifts that can be accepted offhand. Once it sort of elevates to people at a higher level, I think maybe the off-the-rack rule should be more restrictive. And then to the extent that there's anything else, they might have to come to us.
And how would they come to us then? Would it be?
Or they could seek a waiver. They could seek a waiver or another sort of public board disposition. And that would be something where the board would be able to look at a set of facts and say, oh, this is not a prohibited gift within the meaning of the law, as opposed to the application of this rule where no one has to come to us. The teachers and the child protective workers can just be issued these tickets and they can go.
But to Jeff's point, this is a four-factor test. These are requirements. If you don't meet each of these requirements, it doesn't pass.
Correct.
So the first requirement is that it can neither be a supervisor or manager, or we'll change it to manager. If manager is so ambiguous, then people aren't going to understand if they've met the very first requirement, and then they're going to have to come to us. So is there a way to define manager in a way that gets at what Jeff is speaking to? So that we're not, you understand, it becomes so ambiguous that it loses its utility.
Fernando, I think you're right. I think we can try to look at some way of trying to make that a bit more precise, and maybe while doing so, also maybe not having it go quite down as low into the ranks of public servants, so that it allows at least lower level supervisors to participate in this kind of thing. Is that Jeff, am I kind of getting it?
Yeah, because many people may have the title manager, but they'd be in need of some.
There are large chunks of certain agencies that would fall into this category, and frankly, some of those employees at those agencies might not even realize that they are "quote unquote" managers. And certainly, they wouldn't consider themselves managers in the way it would be commonly understood.
That's the sort of thing that maybe we could check with some of our colleagues at the law department about, to the extent that there is a set of magic words that might address those people.
I would check with counsel at DCAS.
That's a good idea.
I think DCAS can be helpful on some level with that, in terms of how they define things in different personnel orders and different civil service titles.
That makes a lot of sense. So we would tighten up I1 Romanet I to address sort of the potential overbreadth of managerial, and we would just drop supervisory as maybe being confusing in the context of Chapter 68, which has separate prohibitions on relationships between superiors and subordinates.
Right.
Yeah, I think that would be useful.
Great. And then of Romanets 3, 4, and 5, the offer having to be unsolicited, and the mechanism for distribution being approved in writing, and lack of involvement by those public servants. Are there any sort of additional issues with respect to those three?
And unsolicited, you mean unsolicited by anybody in the city?
Yes.
And it has to be a voluntary.
Yes, they have to come to the city with this bright idea.
Okay. And not involved in a particular matter, I guess, before that agency is.
It's involvement, full stop. It's not limited to that agency. So if for example, somebody was an official at one city agency, and they were involved in a matter at another agency, which happens. For example, like in the context of housing, somebody who's involved in a housing project at HPD might be involved in a matter that's actually pending before the Department of City Planning. It would still prohibit that public servant from being the recipient of this benefit.
Right, but if the offeror of this benefit is doing business with the city agency, but not particularly the public servants who would benefit, or doing, for example, you mentioned Yankees tickets, for example, which could be offered, as you say, to teachers. but the Yankees do business with the city of New York more broadly. That
Yes.
is not being prohibited.
Right. No, the rule exists to permit that otherwise prohibited gift to be accepted. That otherwise, the Yankees could not offer a gift to anybody.
Chad, let's try this one then. Picking up on Jeff's, in your example of the Yankees, I read this Roman 4 to suggest that the Yankees want to give a bunch of tickets to the Parks Department at a time when the lease for the stadium is in negotiation with parties, including people at Parks. They want to give it to Parks as long as the people that aren't involved in those negotiations go to the agency. The Parks Commissioner gets this offer of 10,000 free Yankee tickets. They can go to low-level Parks people, and the Parks Commissioner is, but the Parks Commissioner is not going to go, and none of his or her staff involved in this negotiation are going to go either. But the 10,000 low-level people are going to go. We'd say good for them, but you kind of wonder if the Parks Commissioner wouldn't get kind of a warm feeling in his or her stomach. So I'm just asking the question.
Right. In that context, the 10,000.
It's too high a number because there aren't that many people that work for Parks anymore, but 1,000.
Right. The 1,000 Parks employees would be permitted to go, provided that they're not involved in the Yankees.
Wow.
And the idea being that these are very low-ranking people, that they're not involved in that. Not being prohibited from going is sort of the goal. And the agency has to approve it in writing, sort of how these people are selected. Usually it's
I may have written some of this language 20 years ago. I'm not sure. Forgetfulness is useful here. But the example gives me a little pause anyhow.
The example gives me pause as well. I think that if I were a commissioner and I had access to a huge lot of tickets to give to my staff, it certainly inures to my benefit in terms of being the good guy and having given out a perk to my staff, and it would likely make me more favorably disposed to the person who gave the gift to the agency.
In that case, the additional restriction of not having business dealings with that city agency, would that sort of address that concern, that this would address the concern of Parks receiving things from entities that have dealings with Parks, DCAS receiving things from entities that have dealings with DCAS, and then leaving the other restrictions in place, or sort of a further tightening of that fourth restriction?
I think as a general policy matter, it's good, but it doesn't mean that it precludes things in the near future that may arise and that may be motivating the giver.
That has or will seek to have business in the city, and then to the extent that this is perhaps an overbroad restriction, people can seek waivers.
I will say, as a practical matter, this rule is more restrictive than the current state of affairs, Wayne, to your point of what's currently existing. And we just haven't seen, like the hypothetical terrible example of 1,000 tickets from the Yankees, we haven't seen that. So I would be wary of crafting a rule based on a worst case scenario that hasn't happened since a sort of existing structure of employees for gifts. Like, this is more restrictive than the sort of quote rule that was established through the Gifts for Employees morale set forth in the AO that's been around for like about 20-ish years.
Yeah.
So just in terms of like the structure that's existed and is essentially functioning, we're trying to pull it back a little bit. I think there might be a value in not putting forward too restrictive a rule that's setting up guardrails that haven't been necessary before, other than in the hypothetical.
No, that's completely fair.
This is obviously the first time the board has seen these 5 proposed rules, even if they are the very end of the train, that sort of each is special. So I revise Romanet I to reflect sort of our discussion with the law department and DCAS, just about targeting those managers better. And then I can tune up 4 to include this provision on business entities that have business dealings with the city agency affected, and we can see how it sort of reads as a whole then.
Just thinking out loud, if it's people have business dealings with the city, that's gonna, I mean, you tend to give to who you know.
Right. For example, if to the extent that the entities that we're thinking about and the proposed targets of these people who would receive these gifts are sort of the city's frontline workers, we're talking about teachers, people who work in parks, people who work in sort of challenging situations at like DYCD and ACS, they tend not to be the entities that have business dealings with the Yankees, Broadway shows, potentially sort of like music events. That universe is pretty big for something that I think is, these are things that they don't have to come to us for. Obviously, the board can always address sort of unique or out of scope issues individually.
Yeah, again, we can think about it. I would be reluctant to add that additional restriction. I think it's overbroad and underbroad at the same time. When we think about like who gets Yankees tickets, it's like every community board in the Bronx. Do they really have business dealings with the Yankees in the Chapter 68 sense? Probably not, but there's sort of different reasons why these things happen. And it's hard to think about like, oh, if Parks has a matter with the Yankees, then a Parks worker who works in Queens shouldn't get I'm not sure. I think we should be thoughtful about making a rule like perfect for every person. It's supposed, there may be some tickets where we're like, we don't love that, but the person's not involved in any matter involving the entity that's giving, and the agency didn't ask for it, and someone else is deciding to give it to that person. There's a fair number of guardrails that are set up in the rule.
Okay, so we'll give it thought and
Okay, we can sort of leave that one cooking while we sort of address those two concerns, and then it'll come back to the board, hopefully at its next meeting or the meeting after, with sort of revisions with the rest of the rule. The next meeting is very soon.
Yes.
yeah, very soon. It's coming up.
So J is donations for personal emergencies, and it sets up a mechanism where really we're talking about what have become GoFundMe drives for people, where a public servant suffers some sort of personal emergency. They're ill, they're injured, they're the victim of the crime, and people want to give to this person. And this would permit a public servant to accept otherwise prohibited donations to that sort of mechanism, provided that they're not solicited from subordinates of the recipient public servant or subordinates of the person soliciting for them, that there is somebody soliciting for them, that the public servant is not fundraising for themselves, that the people still being solicited are not firms that do business with, they're not firms that have pending matters before the beneficiary public servant or the soliciting public servant. And they're not firms with which the public servant or the soliciting public servant are involved in their city jobs. So it's restrictions about who these entities are when they're being solicited. And then at the back end, the donations have to be anonymized, which is something that it's doable on all these sort of donation platforms that come up, that it's possible to anonymize the donations.
This is, as you said, essentially today it would be a GoFundMe proposal.
That's the platform which people use by name when they come to us. There are other platforms available, but that's the one that's most frequent because it's easy.
And there are examples of this now, because I mean this relates to one opinion we drafted some time ago, but this is a live issue, so we do get questions on collections for needy employees.
Frequently, this is a frequent subject of requests for advice. Now,
Burial expenses, that's a big one, right?
Yes.
Funerals, it comes up all the time, right?
funerals, people with terminal illnesses, it's something that I would say now more than ever.
Yeah.
I fielded a large number of calls from city agencies addressing this issue.
I have a very minor and technical question. Ignore me if you like, but I just wonder. 6 looks like a lot, but they're in pairs, and I just wonder if 3 is better than 6. That 1 and 2, 3 and 4, and 5 and 6 each get paired up. I don't know if it makes it easier or harder to read, but I it's a rule of 3. I can't get past 3. 6 is tough.
I don't think I'm allowed to ignore you, Wayne, but even if it's easy, if it might be harder to write, but I'll see if I can make it harder to read.
Yeah.
Harder to read.
Don't make it harder to read.
No, that won't be my goal. I'll see if I can just. You're right. They're parallel. I can see if I can just combine them.
It just looks like a lot of conditions and they could do the same thing with your.
It frankly is a lot of conditions, which is why these otherwise prohibited gifts become acceptable, that they are tightly restricted. And that's sort of the principle here, is that it's a tough standard to meet, but because it's a tough standard to meet, the board feels comfortable with these people accepting them.
But people generally within the agency are going to be doing this soliciting. And so again, we prohibit, you cannot solicit from your own subordinate or from the subordinate of the affected employee. I mean, an agency head could not initiate this. There's somebody who is in dire need, and an agency head could not put out a request that people assist if they can anonymously.
That's right, Jeff. In our experience, it rarely is somebody high ranking, or to the extent that somebody higher ranking is reaching out to us. Right. They're often very receptive to the idea that they should not be doing this. They understand sort of it might make people uncomfortable if their boss is coming to them for something. And often the idea that like a lower ranking person or often somebody administrative would take the reins, this sort of thing, it's well received. And it's often the fact that comes to us that usually these things percolate from bottom to top rather than from top to bottom.
I would think that is the usual way this would happen, but it may be in some situations of significant need, environmental catastrophe or the like, that might result in an agency head. I mean, as long as it's anonymous, is there a danger?
Well, the solicitation is the only restriction. It's not saying that the agency head can't be involved in running, managing, etc. But the actual ask has to come from the lower ranking person. So again, this is how it usually comes to us. It's in response to sort of everything that we've seen, it's rarely a high-ranking person asking to make these asks for themselves. It's usually them trying to see how they can get clearance for their subordinates to run something for the subordinates, coworkers, etc. I think in the event that there is a sort of a general environmental catastrophe, this might be an ill fit for that sort of thing. We might be talking about more general fundraising for the agency, fundraising for affiliated not-for-profits, less fundraising for an individual public servant's GoFundMe.
By environmental catastrophe, I meant that somebody is the victim of a fire or flood, an individual case where there is a lot of money that needs to be raised and somebody's in dire circumstances. Or again, a health emergency where, the agency head is saying, we've got to help our fellow here, and put out a solicitation where everybody would be anonymous, of course, but I don't know that it will happen. I just don't know whether our rule should necessarily prohibit it from happening if, in fact, there is a safeguard and it is anonymous.
I think
for the floods, it's always been, in my experience, sort of low-ranking people at the top, at the front ranks of addressing that situation. Sort of even in the face of sort of the current pandemic, it's never been my experience that high-ranking public servants are the ones either A, organizing it, or B, insisting that their involvement be in the front face.
I understand that. That has not been the experience. My only question is, and you know, if it hasn't happened, maybe we just leave it. But I don't know that it necessarily has to be prohibited. You know, it might be a chief of a division who wants to spur people to assist somebody else within the unit. As long as, you know, we don't solicit from subordinates because there's a pressure. I understand that on that subordinate. But if it is anonymous, and there is no pressure in that regard, I don't know that it ought to be a rule that it can't happen. I don't know how others feel about it. Now, maybe this is academic because, as you say, it hasn't happened.
Jeff, let me offer this. Things like this, and we used to advise to think about this as the kind of thing that came out of HR. Not expectations of people, but of opportunities, and people do want to hear about these, just like they want to hear about raises and the like. And so it comes out of HR, who's nobody's direct superior. It comes out of the office manager or the office manager's assistant, who lets people know about, you know, goodies that are available. And you know, if somebody maybe thinks that it's coming out of that office and that the bosses probably know about it too, then who cares? But just that it doesn't have the agency head's name on the email that says there's a GoFundMe for so-and-so, I think it feels different. And I think this leaves plenty of room for the agency head, if he or she thinks about it, to talk to people that at places like HR, talk to some office manager or the division chief, as you suggest, to have some administrative assistant who's not anybody's superior, but who is known in the office to handle, the cookies in the kitchen. That's that person. Send that email, and everybody's happy about that. That's an opportunity. And there's also a GoFundMe for more seriously for somebody who's quite ill, who has had a fire or a death in the family, and everybody gets the notion that it's coming from that person because the agency kind of cares. And maybe it's a little bit of a wink and a nod, but I don't think so. I think it's useful. It's useful to not have the boss sending those things out. The boss has probably got enough to do anyhow, and it's somebody else's job to let people know about these things, and everybody understands. There's not an expectation, but gosh, I'm sure glad they let me know, because if I have an extra 20 or 50 or $100, I'm gonna go to that GoFundMe account and give it.
If there's general agreement that this is reflective of current practice, and I take Wayne's point. So are there further comments on this section of the rule? Okay, why don't we move on to the final two portions?
Oh, it's not the final one yet, Jack.
Final two, right? Final two.
Great. So K is a codification of sort of existing restrictions on gifts between public servants. So as written, proposed K would prohibit gifts up from subordinates to superiors. A superior cannot accept gifts from their subordinate public servants. It would prohibit gifts across, that colleagues would be permitted to give gifts to each other. We just explicitly permit this, which is the existing standard, as is the prohibition on gifts up, down. And it would prohibit gifts down public servants giving gifts to their subordinates in excess of $1,000.
On that last point,
Yes.
that is not prohibited now.
The existing advisory opinion has sort of no hard dollar limit in its prohibition of sort of contemplated gifts down. And the idea there is that there might be gifts down that are very large or otherwise inappropriate that could somehow interfere with the superior subordinate dynamic. The $1,000 is our attempt to sort of approximate this in sort of a clear way, in an attempt to sort of encapsulate that idea that sort of significant large gifts down might create this sort of unwanted dynamic. It's possible that we might not want a restriction on gifts from superiors to subordinates. It's possible that we might want to raise that number. $1,000 is just sort of the starting point. It's not something that I don't think anyone feels very stuck on.
Right, it's hard to put a precise number on when it would be. I mean, I don't know how frequent it is, but I know that there are situations where superior officers have made substantial gifts to subordinates. I don't know whether we want to tackle that.
It's the other direction.
Yeah, well, the other direction, that's of concern, right?
Right.
In other words, the idea of the subordinate making a gift to a superior is the problem. Here we're talking about superiors making gifts to subordinates, which is not, I think, expressly prohibited in the statute.
It's a limit is contemplated in the advisory opinion that's being codified, and operationally what we see is, in terms of gifts gifts from superiors to subordinates, what we see is Christmas meals. Starting at around October, we start getting calls from superiors asking, can they take their team out to lunch or dinner? The answer is yes. That does not per head ever even come close to $1,000. It's not something that's, this is not a limit that we often see people coming close to. 1,000 is proposed as the absolute cap, but as a live issue, it's that. It's, can I take my team out to lunch? Yes, it comes out to $25, $40 a head. And no one's sort of put out by that.
Can there be a rule essentially that uses 1,000 and say if there's a proposed gift under some circumstances that exceeds that amount, that you come to the board for advice?
Well, any proposed gift in excess of 1,000 would be prohibited absent a waiver. So it's not that they would we should counsel them to seek advice. They're not allowed to do that without discussing that with you.
So that waiver would cover that as well? Waivers deal with prohibited positions, right? Or
The
board's given waivers for gifts many times in the past.
so we interpret our waiver authority to allow that. So,
Yep.
So under those circumstances, so one could seek a waiver.
Yeah.
If, for example, a superior wants to give a painting to a subordinate that the subordinate admired, or a large gift, a large wedding gift or something of that sort, you would seek a waiver to do that if it's over.
Yeah. If, for example, I had a superior that wanted to give me their Rembrandt, they would come and seek a waiver from the board. Because it would be in excess of it, there would be a gift worth in excess of $1,000. It would be a gift from a superior to subordinate. It would fall outside of this safe harbor that we're carving out for lunches, or sort of in terms of like $999 generous gifts permitted within the 1 year span.
But it would be understood, I guess, in the agencies, I guess by the agency council or liaison that.
Yeah, a waiver would have to be approved by an agency. The board It's a prerequisite for the granting of a waiver. So in the event that there's a superior out there who wants to give the subordinate their Rembrandt, they would have to get the agency head approval. That would then come to us, where the board would be able to review the situation and see to ensure that there's nothing really terrible going on.
Okay, that's not a.
Let me add a thought or two, and I'm not sure that I don't think that Jeff's suggestion of maybe being a little explicit on this point of being an exception, but let me maybe a couple of general points. I don't know what. First of all, I don't know what the introductory phrase pursuant to B3, 26.4 B3 means, because I don't know, it seems to suggest that you'd otherwise violate B3 by giving a large gift to your subordinate. And I'm not sure how that's a use of your position.
You're right. It would be a B2 prohibition, that it could conceivably conflict with the discharge of your duties. This is something that the law department's reviewed this, and they didn't have a problem with sort of our legal authority to it. I think you're right.
Every once in a while they swing and miss. Come on.
Yeah, that is not untrue.
I think
once a decade.
Which is pretty good, but you're not wrong that it's an open question as to whether or not, as a policy matter, we think these types of gifts would actually conflict with the proper discharge of a public service duties, especially at the level of $1,000.
And this is going to get real wonky here. And this is not the only time we've done this, I don't think. But remember that this is not like most of the stuff in 68 and most of the rules where we say doing this violates the law. This is saying doing this doesn't violate the law. It's more like the stuff that's in C6. These are really safe harbors, and the converse we assume is prohibited. That is, if you don't fall in the converse, I don't know, whatever the term is, the thing that doesn't fall within the safe harbor is sort of implicitly prohibited. But it makes you wonder whether we, in some way, I think Jeff is suggesting the thing that isn't implicitly, the thing that is implicitly prohibited might not always be would necessarily never be permitted. It's I mean.
If there's a situation where the board doesn't really see itself ever denying somebody the ability to give a gift to a subordinate, striking this prohibition is not beyond the realm of the reasonable. A gift from a superior to subordinate in any real world is not going to be that significant. It's not something that happens.
We haven't seen it yet, I guess.
And for whatever it's worth, the federal government doesn't prohibit it. They have a nearly identical prohibition about gifts between employees, and they do not have any limit on gifts from superiors to subordinates. But we debated. I mean, staff debated this point vigorously. I mean, the advisory opinion 2013-1. I can't remember the language it uses exactly, but it's something like except under unusual circumstances or something like that.
Yeah, I remember we drafted it was something like unusual, highly unusual, just to kind of be there as a guard against the hold your nose case that we couldn't quite imagine. Stuff that begins to feel like a salary supplement, but that would already be prohibited under what whatever that is.
It's either
B13, yeah.
B13? Is that what I'm trying to think of?
Yep.
To the extent that this is largely guarding against the hypothetical that we struggle to articulate, simply including an express permission that superiors are permitted to give the subordinate public servants is a good outcome, because it's very clear and it would address the question that we're asked.
Yeah, and I'm not holding out for the Rembrandt case, but I got a call early on from somebody, and I won't, certainly won't disclose who it was from, but nor the outcome. But this particular relatively high-ranking person wanted to help a subordinate facing eviction, and was going to characterize it as a loan. And I said, well, you can't make a loan to a subordinate. And then but forget the outcome of that particular case. You might want to give a gift in that circumstance, and you know, 1,000, 2,000, maybe even 3,000 might not be enough to prevent a lot of evictions, at least on payment.
We would be happy to include this as a permission for superiors to give gifts to subordinates. That's not a problem.
Or yeah.
Or just a higher dollar amount is another option.
Yeah, we can include it as a blanket permission, or we can turn 1 into 3, 5. That's a judgment call.
Or could we say absent a waiver from the board?
Everything is absent a waiver.
Yeah, I understand, but it looks like it is a clear prohibition. And absent consultation with the board or something of that sort.
Would we want to turn it into a 3 absent a waiver from the board?
But I think the number's not all that significant. 3 and 1. I'm not sure what I can't put a number on it. But we could say absent a waiver, absent consultation or a waiver, or not have it at all. But
What
put a guideline. You know, if you're giving more money to an employee, that's over $1,000. Let's know what it is or why you're doing that, because there may be something there that we want to look at. You may be buying loyalty or the like. So maybe if we explicitly stated without a waiver or absent special circumstances and a waiver from the board or something. That's
How about absent prior approval?
Prior approval from who?
Board.
From the board, right? I wonder if we're circling back in a weird direction, because if, Wayne, you don't think it's a violation of the conflicts of interest law, then on what basis or what exactly would the board be waiving?
Well, no, we'd say effectively you can't do it absent approval from the board. Maybe it's a waiver. Maybe it's a violation. I don't know. And I'd be equally happy to strike it, I guess.
Yeah, I mean, I think striking it is a better result. Otherwise, I'm not sure what the predicate for the board getting involved in, whether we think the reason is good enough or not. Like, what's the factual determination that our interest is the city. So I wonder if that's an arena we want to be.
Well, but the waiver all the time is a judgment call. It's basically who was it?
Oh yeah, no. Of course it's a judgment call, but at least we have a standard that what's the standard we're bringing to this determination?
Same one, purpose and interest, which means is it some way, is it, you know, Jeff's buying loyalty is something, I don't know, but I can't think of these. And maybe if we can't think of them, what the harm is, then maybe we just strike it.
That's the challenge that we've had, is actually articulating what the circumstance is where this poses a genuine rather than merely a technical issue.
So if we were to strike it, and then if in fact a situation did arise where there was an issue, to then at that point legislate.
So in the event that we strike it, there would no longer be a prohibition on superiors giving gifts to subordinates. It would not, however, permit the superior to use their position to benefit themselves. So if they're forcing their subordinate to do something and then they hand them $1,000 afterwards, still the underlying B3 violation exists. If the subordinate does something and superior tips them, still there's an underlying Chapter 68 violation. It would merely remove the gift itself from this sort of galaxy of Chapter 68 prohibitions. It would not, it doesn't really mean no holds barred. It just means that the gift itself is no longer prohibited.
Right, if a superior were inducing the subordinate to do something he should not do and there were money involved, that
Right.
would still be prohibited.
Yeah. The underlying thing is still the problem. It's just that it's no longer, we're no longer stuck on this technical thing of, well, did the superior give a gift to the subordinate?
I support that idea.
Great. We can just strike that and then write it as permission for superiors to give gifts to subordinates, like equivalence.
Well, repeat that? I'm not, could you repeat what you just said?
We'll strike the prohibition.
Yes.
And superiors will be permitted to give gifts to subordinates in the same language that equivalents can give gifts to each other.
Okay, yeah. Okay, and if some situation arose in the future that needed a different approach, we could do that. So
Yes.
do we, is there agreement generally to strike that provision? Okay. And now, there's one other point on this, the $10 limit on birthday gifts and the like to a superior. Is that $10 a gift itself, even if 20 people are contributing? $10 is the size of the overall gift, or $10 per employee?
There's no distinction of sort of, there have been enforcement cases where people have accepted what we could call a sort of like group gifts, where everyone kicks in a small amount of money and it does add up. So public servants are, in the proposed rule, would prohibit public servants from accepting gifts from subordinates or groups of subordinates if it's worth more than $10 or if it's cash.
Right, so an individual subordinate, is $10 the right number today? I mean, what does $10 buy?
$10 is
even a nominal.
Yeah, $10 is an attempt to translate into a rule sort of the general principle that if someone called me on Attorney of the Day, I would say the thought of giving has to be more than the gift itself. It really has to be the thought that counts in a gift from a subordinate to a superior, and $10 is the amount that was arrived on to approximate the value of thought.
Different thoughts, different people's thoughts may be worth more. No, okay, I just wonder whether $10 is just a reasonable number, even for, you know.
I mean,
I don't.
One of the things that makes $10, I mean, it is small and it's supposed to be nominal, and sort of it's one of those situations where after this advisory opinion in 2013, one came out and it has a little footnote that just points to the federal government's rule being no more than a gift no more in value than $10 on an occasional basis. It doesn't actually say that's what the rule is, but everybody wanted to know what's the number. And so since 2013, you know, we and everybody else have just pointed to this $10 number from this footnote. And so it has achieved the status of like the $50 in the gift rule, in that everybody knows it. And so it has some advantage in that it's everyone's aware of that number, and there's not a lot of education that would need to be done about what that number is. And it's, you know, I would say if you're trying to enact something that's of nominal value, $10 I think captures that. It really is nominal.
We're really saying, essentially, you don't give gifts to your superiors.
Exactly.
And that's fine. I mean, that's a fine.
yeah, or a Hallmark that you can still buy a Hallmark card for
$10? I don't know.
for less than $10. It's been a long time since I bought a greeting card.
Same here, so I don't know what they cost. A stamp, maybe that. Okay, and now the final subdivision.
Now the final pair, there's actually a surprise. So
Yeah.
this division of impermissible gifts, L, simply makes sort of the process of removing a gift sequential. So if a public servant receives an otherwise prohibited gift, they have to either return it or donate it to an agency or an entity as defined in the fundraising rules or the mayor's fund. They can share the item within the agency, which is usually done with gifts of fruit, or the item can be destroyed.
Right. Only question I have there, we talk about notice to the Inspector General. Could we say consultation with the Inspector General? Because-
That was the subject of a lot of internal discussion, just
Oh,
because
really? Okay.
agencies have different relationships with their inspectors general. Written notice to the Inspector General was sort of included as the legal requirement, because then after written notice is given, the agency can engage in whatever process they have with their Inspector General. So to the extent that it's an Inspector General that's very involved in the internal workings of an agency, there can be additional discussion. But to the extent that you have an Inspector General that has a more hands-off relationship with its agency, the notice suffices.
Okay, I understand. Okay.
And then
Yeah, go ahead. The
Yeah.
last thing.
finally, compatibility with other laws. This is the result of a merger of provisions of the rules that were sort of tacked on to the ends of other rules, and it has no substantive changes between the proposed version and the existing rules. It's just all in one place now.
Okay. So there'll be those changes we've discussed, and I guess you bring that back at
It'll be back to you.
the next meeting, which is very short.
Guarantee that consultation with DCAS and the law department.
Yeah, okay. So that's great. I think that concludes the open meeting portion of our meeting, and I thank any and all who have tuned in to hear these proceedings. Thank you, and now we'll go into executive session.